The HOA president called it harmless snow. He said that while standing beside a gray mountain of ice, road salt, gravel, trash, and broken maple tubing that covered nearly 3 acres of my certified organic sugar bush. By April, most of this will be water. He told me, "You're treating a temporary condition like permanent damage." His name was Richard Voss. He was 54 years old, president of the developer-controlled Snowcrest Village Homeowners Association and regional manager of a ski property company called Alpine North Communities. Behind him, 2 front-end loaders were pushing another wave of plowed snow over my stone boundary wall. The pile was already more than 20 feet high in places. A blue plastic sled hung from one side. So did a bent parking sign, several aluminum cans, and almost 400 feet of black sap tubing ripped from my trees. Richard gave me 48 hours to remove my sugar house truck from the access lane. He said Snowcrest needed the lane clear for emergency snow operations and would tow any vehicle interfering with its contractors. The lane belonged to me. So did the wall. So did every tree beneath the snow. I asked Richard how much desing salt had been applied to the parking lots before the snow was pushed onto my land. He said that information was irrelevant. I asked whether the HOA had tested the meltwater entering my spring. He said there was no reason to test ordinary snow. Then he offered me $12,000 for a seasonal storage license and told me that refusing would only make the dispute more expensive. I looked at the pile. The snow would melt. The chloride would not disappear. It would move downhill through the root zone of sugar maples my family had tapped for 4 generations. Then enter the spring that supplied our sugar house and 2 neighboring homes. I took the towing notice from Richard's hand, folded it once, and placed it in my coat pocket. Then I called the Vermont Department of Environmental Conservation. Because the HOA had made the same mistake developers often make in winter, it assumed everything white was clean. My name is Ellen Mercer. I was 63 when Snowcrest Village began using Mercer Sugar Farm as its private snow dump. Our property sat outside a small mountain town in southern Vermont, about 7 miles from a ski resort. My great-grandfather purchased the first 40 acres in 1912. My parents added 8 more in the 1970s. The farm was not large by modern standards. 39 acres were forested, mostly sugar maple with pockets of yellow birch, beech, and red spruce. The lower slope held our sugar house, woodshed, equipment barn, and a spring-fed collection tank. We tapped approximately 800 maple trees each winter. Vacuum tubing carried sap downhill to the sugar house, where a reverse osmosis system removed part of the water before boiling. In an average season, we produced between 950 and 200 gallons of maple syrup. The business supported me, Miss Daniel, and 6 seasonal workers. We sold to local stores, shipped online, and supplied 2 specialty food companies in Massachusetts. Mercer Sugar Farm had been certified organic for 11 years. That certification required records for cleaning products, equipment, forest management, sop handling, and potential contamination sources. The organic label did not mean our forest existed in a glass box. It meant we had to protect the integrity of the production system and document what entered it. Road salt was not something I expected to find beneath hundreds of my trees. Snowcrest Village was built uphill on a former motel and pasture property. Alpine North purchased 112 acres and proposed 186 condominium units, a lodge, heated pool, shuttle center, and underground parking beneath 2 of the buildings. The project targeted second home buyers who wanted ski access without owning a detached house. Its advertisements showed fresh powder, stone fireplaces, and families carrying skis past strings of warm lights. It did not show where snow from 12 acres of roads and parking lots would go. The town required a winter operations plan before approving the final phase. Alpine North's plan designated 2 snow storage basins inside Snowcrest property. The larger basin covered 4 acres near the southern entrance. The smaller one sat behind the maintenance building. Both were designed to collect meltwater, trap sediment, and direct flow through vegetated treatment areas before it reached a tributary below the development. Our property shared 800 feet of boundary with Snowcrest's southwest corner. A 40-year-old logging lane ran from my sugar house to the upper sugar bush. Near the boundary, it passed within 70 feet of the larger Snowcrest Basin. The lane had never served the development. Alpine North asked to use it during construction because its own access road was steep and muddy. I agreed to a temporary 6-month license for small utility vehicles. The document prohibited dump trucks, stored materials, grading, and public access. It expired automatically at the end of construction. Richard signed it for Alpine North. Afterward, the contractor repaired 2 rutted sections and returned the gate key. I considered the arrangement finished. During Snowcrest's first winter, I noticed plowed snow stacked near the boundary. The piles remained on the development side and appeared consistent with the approved plan. During the second winter, Alpine North began building a larger fitness center beside the lodge. The new building occupied part of the larger snow storage basin. I assumed the town had approved replacement storage elsewhere. That assumption lasted until January 18. We had received 31 inches of snow over 4 days. Temperatures stayed below 15 degrees, and the roads narrowed as plow crews struggled to find space for additional piles. Daniel and I entered the lower sugar bush before sunrise to repair a vacuum leak. The sap season had not started, but our tubing system was under test vacuum. A pressure drop usually meant a loose fitting, animal damage, or a fallen branch. This leak was not small. The entire southern main line had lost pressure. We followed it uphill and found tubing stretched across the snow like torn wire. Several lateral lines had been snapped from the trees. Plastic fittings lay crushed in tire tracks. Fresh loader tracks crossed the stone wall. Beyond them, a dirty snowbank extended more than 200 feet into our woods. At first, I thought a plow had pushed through the boundary accidentally. Then a backup alarm sounded. A large front-end loader appeared on the logging lane, carrying a bucket packed with gray snow. It drove past us, climbed a temporary ramp built from compacted ice, and dumped the load onto the pile. Daniel stepped into view and raised both arms. The operator stopped. We told him he was on private property. He pointed to a laminated site map inside the cab. The map labeled our logging lane Snow Route C and shaded the lower sugar bush as Overflow Storage Zone 3. The contractor had received the map from Snowcrest Management. We ordered him to leave. He called his dispatcher. Within 20 minutes, Snowcrest's maintenance supervisor arrived with 2 security officers. He said the HOA possessed emergency winter access rights across the lane. I asked to see them. He showed me a copy of the expired construction license. The first page identified the lane. The signature page identified Richard and me. The expiration clause appeared on page 3, which was missing from the supervisor's copy. I retrieved the complete agreement from my office. The supervisor read the missing page and stopped arguing. The loaders left. By then, at least 70 truckloads and loader loads had already been deposited. We closed and locked the gate. Daniel installed 2 trail cameras while I contacted the town zoning administrator. The administrator, Paul Hebert, reviewed Snowcrest's approved winter plan. There was no Overflow Storage Zone 3. There was no Snow Route C. The development storage areas ended at the property boundary. Paul issued a verbal stop work direction and scheduled an inspection for the following morning. That should have ended the dumping. It did not. At 10:47 that night, my trail camera sent an alert. A Snowcrest pickup stopped at the gate. 2 workers cut our chain and removed the lock. A loader entered 18 minutes later. For the next 5 hours, trucks carried snow through the lane and deposited it deeper inside the sugar bush. The cameras recorded license plates, company markings, arrival times, and every load. At 4:30 inches the morning, Daniel and I returned with a sheriff's deputy. The deputy ordered the operators to stop and leave the property. He photographed the cut chain and took statements from the drivers. One driver showed us a work order marked Emergency Snow Relocation Owner Authorized. The authorizing name was Richard Voss. Richard arrived shortly after 7. He claimed the expired license had converted into an ongoing access easement because Alpine North invested money repairing the lane. That was not what the document said. He then claimed an extreme weather emergency allowed the HOA to use neighboring land temporarily to protect public safety. The town had not declared such an emergency. Snowcrest still possessed storage capacity in its smaller basin and several unfinished areas. Using them would have been inconvenient. But inconvenience does not create property rights. I gave Richard a direct choice. Remove the equipment, secure the gate, stop all dumping, provide the dicing records and a plan to remove the contaminated snow under environmental supervision. If he did that immediately, I was willing to focus on cleanup instead of litigation. He refused. Richard said removing frozen snow would damage more trees than leaving it to melt naturally. He offered $12,000 for a seasonal storage agreement and told me the pile would disappear by spring. That was when I called the state. The Department of Environmental Conservation sent an inspector named Nora Patel. Nora arrived with Paul from the town, a representative from the Agency of Agriculture, and a water quality specialist. They did not begin by deciding who owned the lane. The survey and license documents made that issue fairly clear. They focused on what Snowcrest had placed in the forest and where the meltwater would go. Nora collected material from 5 parts of the pile. It contained road grit, trash, petroleum residue, and visible salt crystals. She tested water seeping from the base, even though the air temperature remained below freezing. Chloride levels were more than 30 times higher than the background reading from our upper spring. The pile sat uphill from the Sugar House Collection spring and directly over the root zones of hundreds of sugar maples. Nora asked Snowcrest for its salt application records. The maintenance supervisor said the HOA's contractor maintained them. The contractor said Snowcrest controlled the bulk salt inventory and instructed crews on application rates. Richard's attorney said the records would be provided after legal review. Nora issued an emergency administrative order. No more snow could be placed on Mercer property. Snowcrest had to stabilize the access area, install temporary meltwater controls, and submit a removal plan within 5 days. The order prohibited pushing the pile farther into the woods or allowing concentrated runoff to enter the spring or tributary. The town issued its own notice of violation. Snowcrest had constructed the fitness center over part of an approved snow storage basin without obtaining final approval for an equivalent replacement area. Paul suspended occupancy approval for the fitness center and the final 24 condominium units. Existing residents could remain in their homes. The lodge could operate. The roads could still be plowed. But Alpine North could not open the new facility or close on the remaining units until it corrected the winter operations plan. Richard called me that afternoon. "You've turned a snow removal problem into a development crisis. You cut my lock after the town told you to stop. We had roads to clear. You had your own land. Not enough usable land. That isn't my emergency." He said the state order would cost the HOA hundreds of thousands of dollars. I looked at the damaged tubing hanging from a maple beside the lane. "Then you should have accepted my offer to clean it up before the inspectors arrived." He ended the call. Our first priority was the sugar bush. The pile covered approximately 2.8 acres. A forestry technician counted 317 tapped maples directly buried or surrounded by compacted snow. Another 146 trees stood within the expected meltwater path. The loaders had broken one. 740 feet of lateral tubing and 390 feet of main line. 83 taps had been pulled from trees with enough force to damage the bark. Replacing the plastic system would cost around $38. Ling ling ling. The trees were harder to evaluate. Sugar maples tolerate ordinary snow. A clean snowpack insulates roots. Road salt changes the chemistry. High chloride levels can damage fine roots, interfere with nutrient uptake, scorch leaves, and weaken trees over several seasons. Sodium can alter soil structure and airs, reduce water movement. The full effect might not appear until summer or even the following year. Our organic certifier placed syrup from the affected collection zone on hold pending water and sap testing. That zone included 612 taps, more than the number physically buried by snow because several tubing lines joined before reaching the sugar house. We could keep producing from the rest of the forest, but all sap from the affected zone had to be isolated. Daniel spent 2 days rerouting main lines. We expected our season to begin within 3 weeks. Every lost day mattered. I hired attorney Rebecca Sloan, who had experience with land use and agricultural contamination cases, Rebecca sent preservation notices to Alpine North, Snowcrest, the plowing contractor, the salt supplier, and the engineering firm that prepared the original winter plan. She also hired surveyor Caleb Morris to document the property line and a soil scientist named Dr. Laura Bennett to establish baseline sampling locations. The survey confirmed that the entire pile lay on my land. The nearest edge was 22 feet beyond the boundary. The farthest section extended 286 feet into the sugar bush. None of it overlapped the expired construction license area, except the first section of lane. Snowcrest's insurer contacted Rebecca. It agreed to pay for temporary meltwater controls without admitting liability. Those controls included straw wattles, lined collection trenches, storage tanks, and pumps to capture the most concentrated runoff. We accepted. Preventing more damage did not weaken our property claim. It protected the farm. Richard's attorney proposed leaving the pile in place and treating the runoff until spring. Nora rejected that approach. The pile contained an unknown quantity of salt and debris. Melt rates could increase suddenly during warm weather or rain. The temporary system was not designed to capture millions of gallons from nearly 3 acres of compacted snow. Snowcrest needed to remove it, but it could not simply haul the material to another roadside lot. The snow was now treated as contaminated urban snow, requiring disposal at an approved site with runoff controls. The closest available facility was 19 miles away. The first removal estimate was $486. Ling. Richard called the figure absurd. He proposed pushing the pile back across the boundary into Snowcrest's drainage basin. The state engineer calculated that the basin no longer had enough capacity because the fitness center project had filled and graded part of it. Using the remaining area risked sending chloride-rich runoff directly into the tributary. The state denied the proposal. A second contractor offered to melt the snow on site using mobile equipment, capture the water, and transport it in tanker trucks. That estimate exceeded $700. Ling. Richard returned with a settlement offer. Alpine North would pay me $95. Ling. Repair the tubing and monitor the spring for 1 year. In exchange, I would allow the pile to remain and release the company. HOA and contractors from future tree damage claims. Rebecca read the offer aloud. Daniel laughed once. Without humor, one mature sugar maple might produce sap for generations. We had hundreds at risk, an organic certification hold, and no way to know how far chloride would travel after thaw. I rejected the offer. We countered with practical terms. Snowcrest would fund state-approved removal. It would repair the tubing under our contractor's supervision. It would pay documented production losses. It would establish a 5-year monitoring account for soil, spring water, sap, and tree health. The company would also restore the stone wall and record a declaration confirming that the logging lane was private and that the expired license created no easement. Richard refused. He said 5 years of monitoring was designed to create endless liability. Dr. Bennett explained why 1 year was inadequate. Chloride could flush through shallow soil quickly, but sodium-related soil changes and root damage might take several growing seasons to appear. Trees stressed by salt could also become vulnerable to insects and drought. Richard called that speculative. The Agency of Agriculture called it standard risk assessment. Snowcrest missed the 5-day deadline for an acceptable removal plan. The state began assessing daily administrative penalties. Paul issued a second town notice because the HOA continued using an unapproved overflow area on its own property near the shuttle center. Snowcrest homeowners received an emergency board update blaming extraordinary weather and a neighboring landowner's refusal to permit temporary snow storage. One resident forwarded the message to us. Rebecca replied with the expired license, the trail camera images, the state order, and the survey. We did not post them publicly. We sent them to the HOA's attorney and requested a correction. Richard issued a revised message. It removed the phrase refusal to permit but described ownership of the access lane as disputed. The recorded deed and survey did not show a dispute. They showed my land. Homeowners began asking how the HOA lost use of its approved snow basin. That question led back to the fitness center. Alpine North had marketed the facility as a $6.4 million improvement funded by developer contributions and future amenity fees. The construction plans expanded the building footprint by nearly 40% after the original winter operations plan was approved. An engineering note warned that the expansion would displace approximately 38,000 cubic yards of snow storage capacity. The engineer recommended acquiring a replacement area before construction. Richard signed the note. No replacement area was acquired. Instead, a later site map relabeled my logging lane as Snow Route C and my lower sugar bush as Overflow Storage Zone 3. The map had never been submitted to the town. It existed only in Snowcrest's internal operations file. Rebecca requested every version. Alpine North produced 4. The first showed the approved basins. The second showed the fitness center expansion. The third marked potential off-site storage near my property. The fourth removed the word potential and added my lane as an access route. That final map was created 6 days after I declined Richard's offer to purchase a winter storage easement the previous summer. I had almost forgotten that offer. Richard had proposed paying $18,000 per year for the right to store clean snow on half an acre beside the boundary. I refused because the site drained toward our spring and because clean snow from roads rarely remained clean. He told me Alpine North would identify another solution. Instead, he expanded the storage area from half an acre to nearly 3 acres, drew it onto an internal map, and used it without telling me. The plowing contractor then delivered its dispatch records. Between January 14 and January 19, Snowcrest sent 412 truckloads and loader loads through my lane. The estimated volume was 31,600 cubic yards. Bulk salt record showed that the roads and lots had received approximately 96 tons of sodium chloride and treated salt during the storms. Nobody could determine exactly how much entered the pile, but runoff testing confirmed that the concentration was not minor. The state approved a phased removal plan submitted by a new environmental contractor. Work would begin at the outer edge, where the snow covered the most trees. Each load would be screened for large debris and hauled to the approved facility. Meltwater would be captured throughout the operation. The estimated cost rose to $568. Ling ling ling. Snowcrest's insurer agreed to advance part of the expense but reserved its right to deny coverage for intentional trespass after the first stop order. That distinction mattered. Loads deposited before Richard knew the license was invalid might be treated differently from loads deposited after he cut the replacement chain and authorized nighttime entry. The trail camera timestamps separated them perfectly. Alpine North's lender became involved when the town suspended the condominium approvals. The lender had financed the fitness center expansion based on a certification that all site plan conditions remained satisfied. Richard signed that certification 3 weeks before the storm. It stated that required snow storage capacity had been maintained. The engineering note in his file said the opposite. The bank froze the remaining $2.9 million amenity draw and requested an independent review. Richard responded by blaming the project engineer. The engineer's firm produced 2 emails. In the first, it warned Richard that Mercer Sugar Farm could not be used without a recorded agreement and town approval. In the second, Richard replied, "Do not put off-site snow in the permit revision. We will handle Mercer directly if capacity becomes an issue." The bank asked for evidence that he had handled anything with me. Alpine North could provide only my written refusal. By then, homeowners were demanding a special meeting. Snowcrest had 162 occupied units, each paying monthly assessments between $590 and $840 depending on size. Owners feared they would receive a special assessment for the removal, penalties, and fitness center delays. Richard told them insurance would cover most costs. The insurer issued a written correction. It had made no such commitment. A group of 29 homeowners hired an independent attorney and requested access to the snow contracts, engineering reports, and fitness center approvals. Alpine North controlled the board and initially refused. The owners filed a records action under the HOA statute. The court ordered production of non-privileged financial and operational documents. That was how they found the snow storage budget. For 2 years, Snowcrest had collected $176,000 annually for plowing. hauling, and approved off-site disposal during major storms. The plowing contractor had billed separately for hauling every load placed on Mercer's sugar farm. The invoices totaled $214. Bay. Each invoice contained a disposal charge of $185 per load, but the contractor had not paid an approved disposal facility. A side agreement directed it to return 70% of the disposal fees to a company called Voss Winter Logistics for site access and capacity coordination. Voss Winter Logistics was owned by Richard's adult son. The company had been formed 4 months before the fitness center expansion. It owned no land. It operated no snow facility. It held no environmental permits. And its supposed storage site was my organic sugar bush. The homeowner's attorney asked Richard to explain why his son's company received money for access to land. The Voss family did not own. Richard answered through counsel. Voss Winter Logistics, he said, had provided legitimate route planning, weather coordination, contractor scheduling, and emergency capacity consulting. The company did not claim to own Mercer Sugar Farm. It merely identified the property as a potential storage location based on Alpine North's prior access agreement. Our access agreement had expired. My later refusal was in writing, and after the town ordered the dumping to stop, Richard cut my chain and sent the loaders back at night. The word potential did not survive those facts. The homeowner's attorney requested every Voss Winter Logistics contract, timesheet, employee record, and work product. Richard's son, Ardon, produced a 6-page consulting agreement and 3 invoices. The company had no employees besides him. It had no dedicated office, equipment, insurance policy, or environmental consultant. Its work product consisted of the unauthorized map labeling my land overflow storage zone 3 and a spreadsheet calculating disposal charges. The spreadsheet showed that Snowcrest paid $185 for each load, supposedly hauled to an approved off-site facility. The actual additional cost of driving from the Snowcrest parking lots to my sugar bush was approximately $42 per load. After fuel and contractor charges, the remaining amount was divided between Voss Winter Logistics and an Alpine North budget account controlled by Richard. Homeowners had not been charged only for plowing. They had been charged the price of lawful disposal while their snow was dumped illegally on my land. Margaret Ellis, a retired municipal finance director who owned a 2-bedroom unit at Snowcrest, explained it during the next HOA meeting. If we paid a disposal fee, she said, then someone should be able to identify the disposal facility. Richard said Mercer Sugar Farm had been the facility. Margaret asked where my payment appeared. He said payment was pending resolution of the property dispute. There was no dispute when you billed us. She said, you represented that disposal had already occurred. Richard tried to move to the next agenda item. 41 owners objected. The meeting ended without a vote. But the homeowners had learned enough to seek an emergency order preventing Alpine North from transferring more HOA funds to Richard, his relatives, or related companies. The court did not remove the developer-controlled board. It issued a narrower order. Any related party payment above $10,000 required advance notice to the homeowner committee and supporting documentation. Snowcrest also had to preserve all accounting, plowing, and snow storage records. That order arrived while the environmental contractor was preparing to remove the pile. The work began on February 9. Temperatures remained below freezing, which helped. Solid snow could be excavated and hauled with less runoff than partially melted material. The contractor divided the affected area into numbered cells. Every truck received a load ticket identifying its source cell, estimated volume, departure time, and approved destination. The contrast with Snowcrest's original operation was obvious. The first crew had entered at night through a cut lock and treated my woods as free space. The cleanup crew operated in daylight under state supervision, with spill controls, traffic plans, soil protection mats, and independent inspectors. Removal progressed at about 50 loads per day. At that pace, it would take more than a week, even if the weather remained stable. It did not. On the 5th afternoon, the forecast changed. A warm front was expected to bring heavy rain and temperatures above 45 degrees. The state engineer warned that rapid melting could overwhelm the temporary trenches and tanks. The contractor added pumps, lined another collection area, and extended the downhill barrier. Snowcrest's insurer paid for the emergency work while continuing to reserve its coverage rights. Richard complained that the state was overreacting to ordinary meltwater. Nora Patel invited him to observe the sampling. Water draining from one section of the pile contained chloride above 300 milligrams per liter. The background concentration in our upper spring was 22. Some runoff samples also contained elevated petroleum compounds, though most remained below hazardous waste thresholds. The snow was not toxic waste in the dramatic sense Richard accused us of claiming. It was still contaminated enough to damage freshwater systems, soil, and sensitive vegetation. Ordinary snow does not contain parking lot grit, fuel residue, litter, and concentrated road salt. The rain began shortly after midnight. Daniel and I stayed at the sugar house with the environmental crew. Pumps moved, captured water into temporary storage tanks. Tanker trucks arrived every 2 hours. At 2:40 inches the morning, a debris screen clogged with gravel and pine branches. Water rose behind the barrier. One of the pumps lost suction. For 12 minutes, meltwater escaped around the western edge and entered a shallow swale leading toward the spring. The crew corrected the problem quickly, but nobody pretended nothing had happened. Dr. Bennett sampled the swale, spring, collection tank, and soil. The spring's chloride level increased from 31 milligrams per liter to 146. That concentration was below the federal secondary drinking water guideline associated with noticeable salty taste. But it was far above our normal background and high enough to confirm that contamination had traveled downhill. We stopped using the spring for sugar house cleaning. The insurer funded potable water tanks and temporary plumbing. 2 neighboring homes connected to the same spring switched to bottled water until repeated testing confirmed safe conditions. Richard later said the emergency system had worked because the spring remained drinkable. That missed the point. The system reduced the damage. It did not erase the release or make the original dumping acceptable. Removal continued for another 9 days. The final count reached 438 truckloads. Some trucks carried more than the vehicles that originally entered because the disposal contractor used larger trailers. The approved site weighed each load. The total contaminated snow and debris exceeded 26,000 tons. Crews recovered broken sleds, vehicle parts, plastic bottles, coffee cups, parking signs, torn landscaping fabric, pieces of curb, and 3 shopping carts. Nobody could explain how the shopping carts reached a private mountain condominium development. Once the snow was gone, the forest floor looked worse than I expected. Loader tires had compacted the soil between trees. The stone wall had been flattened across a 60-foot section. Bark was scraped from several maples. Broken tubing hung at different heights, and gravel covered portions of the logging lane. Dr. Bennett took soil samples at 3 depths across a grid. The surface results varied widely. Cells near the center of the former pile contained sodium and chloride concentrations capable of damaging sensitive roots. Downhill cells showed a clear contamination path toward the spring. She recommended removing heavily contaminated gravel, applying gypsum only where soil tests supported it, improving drainage without cutting roots, and monitoring conductivity through multiple seasons. She warned against aggressive excavation. Digging out every area could injure more roots than the salt. The restoration plan had to reduce contamination while preserving the trees. That required patience. Our maple season began during the final week of removal. Warm days and freezing nights created good sap flow in the upper sugar bush. The unaffected zones performed normally. The isolated southern zone did not. Some vacuum lines remained disconnected. Others had been repaired but showed poor flow because damaged fittings leaked. We collected sap from selected trees into separate tanks and sent samples to a laboratory. Chloride levels in the sap remained low. That was encouraging. But our organic certifier required continued segregation because soil and spring contamination was still under investigation. We produced 814 gallons that season. nearly 200 below our 5-year average. Part of the decline came from weather. Part came from lost taps and damaged equipment. Our accountant and forestry consultant separated those factors as carefully as possible. Documented production loss attributable to the dumping was estimated at $96,000 for the first season. Richard called the number inflated. He compared our total syrup production with a low-yield year from 6 seasons earlier. Rebecca compared it with the 5-year average. Tap count, sugar content, and production from unaffected zones during the same weather. The unaffected trees produced 14% more syrup per tap than the damaged zone. Data made the argument less emotional. It did not make Richard more cooperative. Alpine North offered $280,000 to settle the farm's claims. The offer excluded the cost of snow removal because the insurer was paying that separately. It included tubing repair, first-year production loss, and 1 year of environmental testing. It also required me to grant Snowcrest a permanent emergency access easement over the logging lane. The easement prohibited snow storage but allowed the HOA to use the lane during severe storms, utility failures, evacuations, and other events determined by the HOA board. That language could turn nearly any inconvenience into a claimed emergency. I rejected it. Our counter-proposal remained straightforward. No permanent access, full repair, 5 years of tree, soil, spring, and sap monitoring, compensation for documented production loss, a restoration fund controlled by independent professionals, a recorded boundary declaration. Rebecca also demanded that Alpine North reimburse the HOA for disposal fees connected to my property. That money did not belong to me. It belonged to the homeowners who had paid for a service they did not receive. Richard refused. He insisted HOA finances were outside the scope of my claim. The homeowner's attorney agreed that their reimbursement claim was separate. Then she filed it separately. Snowcrest owners sued Alpine North, Richard, and Voss Winter Logistics for repayment of unauthorized related party charges, breach of fiduciary duty, and access to additional financial records. Alpine North's investors had tolerated the environmental dispute as a difficult winter operations problem. The related party lawsuit changed their view. The company appointed an internal investigator named Caroline Price. Caroline was a former construction attorney who specialized in troubled resort projects. She interviewed Richard, Aaron, the plowing contractor, Snowcrest employees, and the engineer. She also met with me. Her questions were precise. Had I ever authorized Voss Winter Logistics to represent my property as a snow facility? No. Had I ever received money from the company? No. Had I ever provided Richard with a gate code after the construction license expired? No. Did I refuse the $18? 000 seasonal offer. Yes. In writing. Did Richard understand why? I gave Caroline the email. It said the proposed area drained toward our sugar house spring, threatened organic certification, and could not be used for road snow. Richard replied, "Understood. We will make other arrangements." Caroline read that sentence twice. When did the dumping begin? 6 months later. She asked for the trail camera files. Rebecca provided authenticated copy. The video showed Richard's pickup at the gate before the chain was cut. It showed workers speaking with someone by phone. It showed loaders entering after the town's stop direction. Richard claimed he had gone to the gate to assess road conditions and did not personally order anyone to cut the chain. The driver work orders bore his approval. The dispatcher's log listed a call from his cell phone. The contractor's supervisor signed a sworn statement, saying Richard instructed him to reopen Snow Route C because Mercer can fight about access after the storm. Caroline issued a preliminary report to Alpine North's board. She concluded that Richard knew the license had expired. I knew I had rejected snow storage, knew the fitness center expansion, displaced approved capacity, and approved payments to a company owned by his son without proper disclosure. The board suspended him from financial authority. He remained nominal HOA president because Alpine North controlled the appointment, but every check required another signature. He could no longer direct contractors or communicate with regulators without company counsel. Caroline became interim project administrator. Her first decision was to accept the state-approved restoration framework. Alpine North placed $720,000 into an environmental and agricultural escrow. The amount covered soil treatment, spring water infrastructure, tubing reconstruction, tree monitoring, organic certification expenses, and future documented losses. Unused funds would return to Alpine North after 5 years. The insurer continued paying removal and emergency control costs separately. Caroline also hired a different engineering firm to solve Snowcrest's permanent snow storage problem. The new firm identified 3 options. The first was to demolish part of the fitness center addition and restore the original basin. The second was to purchase a 6-acre gravel yard north of the development and construct a lined snow storage facility. The third was to install heated pavement and a mechanical snowmelt system beneath 2 parking areas. The mechanical system sounded attractive but required enormous energy use and would still need water treatment infrastructure. The gravel yard option cost $1.9 million, including land, drainage, permitting, and road improvements. Restoring the original basin cost less, but would delay the fitness center and remove several features already promised to buyers. Alpine North chose the gravel yard. The owner knew Snowcrest needed the property and negotiated accordingly. The final purchase price was nearly double its assessed value. The town required a lined sediment basin, chloride monitoring, restricted operating hours, and a truck route avoiding the village center. Only after Alpine North recorded the new storage plan did Paul agree to reconsider the suspended occupancy approvals. The fitness center remained closed. The final 24 condominium closings remained on hold. The lender released enough money to purchase the gravel yard but maintained the broader amenity freeze pending its audit. Richard accused Caroline of surrendering to regulators and spending millions to solve a temporary problem. Caroline's written response listed the alternatives. Alpine North could provide lawful snow storage. It could redesign the fitness center. Or it could reduce the development area requiring plowing. Using Mercer Sugar Farm was not an option. That sentence appeared in the board minutes. It was the first time the company had treated my ownership as a fact instead of a negotiating obstacle. The judge in our trespass case granted a permanent preliminary injunction while damages remained pending. Snowcrest, Alpine North, Voss Winter Logistics, and their contractors could not enter Mercer property without my written permission. The order confirmed that the expired construction license created no continuing easement. The lane was mine. The state restoration contractors received limited access through written agreements naming their employees, vehicles, hours, and purpose. Nobody else did. Richard's attorneys tried to argue that my strict access terms delayed cleanup. The daily logs showed otherwise. We approved every legitimate restoration request within 24 hours. The only requests we denied involved storing equipment overnight outside the designated area and allowing Snowcrest maintenance staff to use the lane as a shortcut. Protecting a boundary was not obstruction. It was the reason we had a boundary. The HOA financial audit expanded. Voss Winter Logistics was not the only related company. Over 18 months, Snowcrest paid $438,000 to businesses owned by Richard's relatives for landscaping consultation, shuttle scheduling, storage coordination, and event management. Some services appeared legitimate, others lacked bids, work logs, or clear deliverables. The homeowner's accountant separated each payment. Instead of assuming every family connection was fraudulent, that made the findings stronger. The snow storage charges remained the clearest. Snowcrest paid $214. Sissons for disposal. Voss Winter Logistics received $105. By Susher, Alpine North received $42.500 as an administrative reimbursement. The plowing contractor retained the rest for hauling and equipment. No money went to an approved disposal facility. No money went to me. Richard testified that his son's company deserved payment because Aaron had identified a viable emergency site. Rebecca asked him during deposition what made the site viable. It was accessible from the development. Did your company own it? No. Did the HOA own it? No. Did your son own it? No. Did Ellen Mercer authorize snow storage? Not formally. She refused in writing. Correct. She declined the original proposal. Did she later agree? No. Then what access did Voss Winter Logistics sell to the HOA? Richard said the payment covered coordination. Not access. Rebecca showed him the invoice. The description read, off-site capacity reservation and land access fee. He said the wording was imprecise. She showed him the spreadsheet dividing disposal charges. He said accounting staff prepared it. She showed him his approval. He said he relied on his team. For nearly an hour. Every deliberate choice became an imprecise phrase or someone else's responsibility. Then Rebecca asked about the night the chain was cut. Richard denied ordering it. She showed him the dispatcher's sworn statement. He said the dispatcher misunderstood. She showed him the supervisor's work order. He said owner authorized referred to Alpine North's authority under the old agreement. She showed him page 3, containing the expiration clause. He said he believed severe weather revived emergency rights. What language in the agreement says that he could not identify any? The deposition ended late in the afternoon. Richard left with his attorney. Caroline remained behind. She had received another production from the plowing contractor that morning. The files included deleted text messages recovered from a company phone. She gave copies to both sides under the discovery agreement. One conversation began the afternoon. Paul issued the verbal stop direction. The contractor's supervisor wrote, "Town says Mercer is off limits." She locked the lane. "We still have 200 plus loads with nowhere approved to go." Richard replied, "Cut it if you have to. Move everything tonight before state people arrive." The supervisor answered, "What do we use for disposal tickets?" Richard wrote, "Same site code. Bill full off-site rate. Aaron will handle the access paperwork later." Then, 20 minutes after midnight, Aaron sent his father a final message. "She'll see the pile in the morning." Richard's response was 6 words. "By then, the storm is our excuse." The messages ended Richard's claim that the nighttime dumping resulted from confusion. He knew the town had prohibited entry. He knew my gate was locked. He knew the contractor lacked an approved disposal site. He ordered the chain cut, told the crew to move more than 200 loads before state inspectors arrived, and directed them to bill homeowners the full off-site rate. The storm was not the reason he used my land. It was the excuse he planned to use after he was caught. Caroline presented the messages to Alpine North's board the following morning. Richard's suspension became a termination. He was removed as regional manager, stripped of authority over Snowcrest, and replaced as developer-appointed HOA president. Aaron's company was barred from receiving additional project funds. Alpine North also demanded that Voss Winter Logistics return every dollar connected to the unauthorized storage site. Richard called the messages incomplete and taken out of context. The board asked him to provide the missing context. He did not. The contractor's phone contained the full conversation, with timestamps, delivery confirmations, and replies from accounts Richard and Aaron admitted using. There was no missing message granting access. There was no emergency declaration. There was no permission from me. There was only an instruction to cut the chain before regulators arrived. Snowcrest's insurer amended its coverage position. It continued funding emergency removal and measures necessary to prevent further environmental damage. Those expenses protected the farm, residents, and surrounding watershed, but it warned that intentional trespass, deceptive billing, and payments to a related company might not be covered. That distinction placed millions of dollars directly onto Alpine North, Richard, Aaron, and the plowing contractor. The contractor's insurer responded by seeking an early settlement. Its company had entered my land and deposited the snow, but the work orders, map, billing instructions, and nighttime directive had come from Richard. The contractor admitted it should have stopped after seeing the expired license and the town's order. Its insurer agreed to contribute to restoration, equipment replacement, and legal expenses in exchange for a release. Limited to the contractor's role, we accepted after Rebecca confirmed that the agreement did not reduce claims against the other parties. The contractor also provided 2 years of dispatch records and agreed to cooperate with the state investigation. Alpine North requested mediation. This time, Richard did not control its position. Caroline attended with company counsel. an insurer representative, the lender's project monitor, and an independent member of Alpine North's board. Snowcrest homeowners participated through their own attorney. The plowing contractor joined from a separate room. Richard and Aaron attended with personal counsel for 2 days. The mediator moved between us. The first major disagreement involved the maple tree. Alpine North wanted to value only trees already dead or visibly damaged. Dr. Bennett explained that salt injury could appear gradually. A maple might leaf out normally in the first summer, show crown thinning in the second, and decline after drought in the third. The soil remained part of the injury even if every tree survived. We proposed a 5-year monitoring period with objective release standards. Tree health would be measured using crown density, annual growth, sap yield, soil conductivity, chloride concentration, and root zone condition. Funds would be released only for verified losses and approved restoration. That protected both sides. I could not claim healthy trees as dead. Alpine North could not declare the forest recovered after one green summer. Caroline agreed. The second disagreement involved organic certification. Our certifier had not revoked Mercer Sugar Farm status. It placed only the affected collection zone on temporary hold while testing continued. Alpine North wanted the settlement to state that no certification loss occurred. Rebecca refused. The hold created additional labor, segregated storage, testing costs, and reduced production. The fact that we prevented a full revocation did not make those expenses imaginary. The final language described exactly what happened without exaggeration. The third disagreement involved the logging lane. Alpine North requested a limited emergency easement for evacuation if Snowcrest's main entrance became blocked. I asked the town fire chief whether the lane formed part of any approved emergency route. It did not. Snowcrest had 2 code-compliant access connections on its own property. The requested easement was removed from the settlement. The lane would remain private. On the second evening, we reached a framework. Alpine North accepted the $720,000 environmental escrow. Caroline had already established and added another $480,000 for potential tree and production losses. The combined fund would remain under independent control for 5 years. The company paid separately for the tubing system, stone wall, spring water equipment, first season syrup losses, professional costs, and part of our legal fees. The plowing contractor and insurers contributed to those amounts according to their negotiated shares. The total immediate payment and funded restoration commitment exceeded $1 million, not including the original snow removal. The agreement required a recorded declaration confirming that Snowcrest possessed no easement over my logging lane or sugar bush. Every internal HOA map had to remove Snow Route C and Overflow Storage Zone 3. Alpine North had to disclose the corrected winter plan to current owners and future buyers. No confidentiality provision prevented us from discussing public environmental records or court filings. The settlement resolved claims against Alpine North, the HOA, and the contractor. If they performed every obligation, it did not release Richard, Aaron, or Voss Winter Logistics from the homeowner's financial claims or from liability for conduct excluded by insurance. Separating the farm's recovery from Richard's personal refusal was important. Trees do not wait for a defendant to become cooperative. The court approved the agreement and kept jurisdiction to enforce the restoration requirements. Spring testing began immediately. Dr. Bennett installed monitoring wells between the former pile and the sugar house spring. She established control plots in an unaffected section of forest with similar slope and soil. We measured conductivity after snowmelt, spring rain, dry summer weather, and autumn storms. The highest chloride concentrations appeared in the upper 12 inches of soil near the center of the former pile. Levels declined downhill but remained elevated along the swale that overflowed during the rain event. The restoration contractor removed contaminated gravel and road debris by hand around tree roots. Where testing showed sodium accumulation, crews applied carefully, calculated gypsum and organic material. They did not spread treatment across the entire area. Soil amendments can cause harm when used without evidence. Compacted sections received shallow aeration using equipment designed to avoid major roots. The stone wall was rebuilt with rock recovered from beneath the pile. Daniel supervised the tubing replacement because our vacuum system had been modified over the years and standard plans did not show every connection. By late summer, the physical damage looked smaller. New tubing ran between the trees. The wall stood again. Leaf litter covered much of the disturbed ground. The visual recovery was faster than the biological recovery. 21 maples developed scorched leaf margins during the first summer. 9 showed significant crown thinning. 3 died. The following spring, another 14 failed to leaf normally. Dr. Bennett examined each one. Some decline came from age or unrelated defects. Mature forests are never perfectly healthy. Only trees within the contamination pattern and without stronger alternative causes were charged to the restoration fund. That careful approach frustrated people who expected us to claim every weak tree. I wanted our evidence to survive scrutiny. By the end of the second year, experts attributed the death of 11 mature sugar maples and severe decline of 27 others to salt exposure and mechanical damage. Another 64 required continued monitoring. Replacing a mature sugar maple is not like replacing a landscape shrub. A young tree can be planted in the same area, but it will not produce comparable sap for decades. Direct replacement cost captures only part of the loss. Our forestry economist calculated lost syrup production, future management costs, reduced timber value, and the time required for younger trees to enter the tapping rotation. The escrow paid those documented amounts. We planted 53 young maples in suitable openings, more than the number of trees lost. Planting one sapling beside every damaged mature tree would have crowded the stand and reduced survival. The restoration followed forestry principles, not symbolic arithmetic. The spring improved steadily. Chloride concentrations rose during early snowmelt, and then declined after clean spring runoff. By the third year, most readings remained close to background levels, with brief increases after major storms. The 2 neighboring homes returned to normal spring use after repeated drinking water tests passed. We continued using an upgraded filtration and storage system at the sugar house because the settlement had already funded it and because the additional protection made sense. Our organic certifier released the affected collection zone after 2 seasons of acceptable sap, soil, and equipment tests. No contaminated syrup reached customers. The syrup held during the first season tested within safe limits. But we did not sell it under the organic label because segregation records were incomplete during the emergency repairs. The settlement compensated that loss. When our full certification was restored, Daniel framed the letter and hung it in the sugar house office. He placed it beside the original certificate from 11 years earlier. Snowcrest's permanent snow facility opened before the next winter. The gravel yard had a reinforced entrance, lined storage cells, sediment traps, runoff tanks, and automated chloride monitoring. Trucks scanned electronic tickets when entering and leaving sleighs. Each load had a real destination. The town inspected the site before the first storm. Alpine North also revised plowing routes to reduce hauling. Several parking areas received lower salt treatment plans, and maintenance crews began calibrating spreaders instead of applying salt by rough visual estimates. The changes reduced annual salt use by nearly 30% without creating unsafe roads. The fitness center finally received occupancy approval 9 months late. The final 24 condominiums closed in stages after the lender accepted the corrected winter plan, and Alpine North contributed additional cash. No residents lost their homes. No one had to remove the fitness center. The development survived because Caroline spent money on infrastructure that should have existed before construction. The homeowner's case took longer. Voss Winter Logistics refused to return the $105.140 it received. Aaron claimed he earned the fee by coordinating hundreds of loads during a severe storm. The homeowner's attorney asked him to identify the lawful storage site he coordinated. He said his company relied on Alpine North to secure access. She showed him my refusal. He admitted Richard forwarded it to him. She showed him the internal map Aaron prepared after receiving that refusal. He said the property remained a potential emergency option. She showed him the message stating he would handle access paperwork after the snow was dumped. He said he expected Alpine North's attorneys to resolve the issue. "What paperwork did you prepare?" she asked. Aaron produced a draft seasonal license. It listed Mercer Sugar Farm as the property owner. The signature line for me was blank. The document offered $18. Ling, ling, ling. It was created 2 days after the pile was discovered. Aaron had prepared the agreement after using my land, then expected to obtain my signature retroactively. The homeowners sought summary judgment on the snow disposal charges. The court found that disputed facts remained concerning some consulting services, but it ruled that Voss Winter Logistics had no basis to retain a land access fee for property it did not own or control. Aaron returned the $105, $140 with interest. Alpine North reimbursed the remaining improper disposal markup and the HOA's audit expenses. The total credit to Snowcrest exceeded $260. Ling, ling, ling. It was applied against the following year's operating assessments. The owners did not receive every dollar they demanded. The plowing contractor had performed real hauling work, and Snowcrest had received necessary snow removal from its roads. The court separated legitimate services from improper charges. That made the outcome less dramatic than canceling every invoice. It also made it fair. Richard faced claims from Alpine North for breach of his employment duties and undisclosed related party transactions. The company withheld deferred compensation and demanded repayment of losses not covered by insurance. He countersued, claiming Alpine North had approved the fitness center expansion and benefited from his winter decisions. Company board minutes showed that executives approved the expansion based on Richard's certification that replacement snow capacity had been arranged. He had not told them the replacement site belonged to me. The parties settled before trial. Richard surrendered $640, 0 inches deferred compensation, and paid an additional amount from personal funds. He resigned from all positions associated with Alpine North and agreed not to serve on a Snowcrest board. Aaron dissolved Voss Winter Logistics after resolving tax, repayment, and legal obligations. The state imposed environmental penalties on Alpine North. After resolving tax, repayment, and legal obligations, the state imposed environmental penalties on Alpine North, the contractor, and Richard based on their separate roles. Richard's portion reflected the nighttime order issued after the stop direction. The town assessed its own fines for using an unapproved snow storage area and submitting an inaccurate capacity certification. No one went to prison. The conduct produced civil, regulatory, employment, and financial consequences. That was where the evidence led. Snowcrest homeowners elected their first independent board 18 months earlier than the original turnover schedule. Margaret Ellis became treasurer. A ski instructor named Peter Lang became president. Their new contracts required disclosure of related ownership, competitive bids above defined limits, and proof of licensed disposal sites. Every winter, the property manager provided the board with storage capacity reports before the first major storm. The rules did not prevent snow. They prevented the HOA from pretending someone else's land was part of its maintenance plan. Peter asked to meet me at the rebuilt stone wall. He apologized on behalf of the homeowner-controlled association. I told him individual residents had not cut my chain or ordered the dumping. The HOA name was on the notice. He said, "We should still acknowledge what happened." He gave me a written statement, confirming that the lane and sugar bush were private property. I gave him my phone number for true emergencies, not snow storage emergencies, real ones involving fire, injury, or immediate danger. Good boundaries do not require neighbors to stop helping each other. They require help to remain voluntary. 5 years after the dumping, Dr. Bennett completed the final monitoring report. 38 maples had died or declined enough to be removed. 81 showed temporary stress but recovered. The younger replacement trees were growing well. Soil chloride had returned close to control levels across most of the area. 2 small cells still showed elevated sodium, but concentrations continued to decline and no additional treatment was recommended. The spring met drinking water and organic production standards. Our syrup yield returned to its historical range. The final restoration expenses and verified losses used most of the escrow, approximately $167. 000 remained unused. It returned to Alpine North under the agreement, Rebecca asked whether I was comfortable signing the final release. I looked at the reports. The farm had been compensated for what the evidence supported. The remaining risk was no greater than normal forestry uncertainty. Yes, I said. We made them keep their promise. Now we keep ours. The final accounting placed the total cost of Richard's decision at more than $5. 7 millions. That included snow removal, environmental controls, the new storage facility, delayed condominium closings, lender expenses, restoration, production loss, homeowner reimbursements, penalties, legal fees, and settlements. Snowcrest had already budgeted enough money to haul major storm snow to a lawful facility. Richard could have delayed the fitness center expansion. He could have purchased replacement capacity before construction. He could have reduced the building footprint. He could have returned to me with a different proposal. I might still have refused. That was the possibility he was unwilling to accept. He wanted my land available whether I agreed or not. So he created a map, hired his hired son's company to sell access it did not own, cut my chain, dumped 600 cubic yards of salted snow into the sugar bush, and billed homeowners as though every load had gone to an approved facility. For one night, the scheme looked efficient. Snowcrest's roads were clear. The trucks kept moving. The disposal tickets were completed. My woods were hidden beneath a white pile that Richard said would vanish by April. He was right about one thing. The snow melted, but the salt entered the soil. The trucks left dispatch records. The invoices entered the HOA accounts. The trail cameras captured the gate. The deleted messages remained on the contractor's phone, and the trees kept their own record in damaged roots, reduced sap, and thinning crowns. Today, Mercer Sugar Farm taps just over 4,000 maples. Daniel manages most of the operation now. I still handle certification records and refuse to let anyone modernize my paper notebooks. The section beside Snowcrest looks like a working sugar bush again. If you know where to look, you can see younger trees growing among older trunks and a rebuilt section of stone wall that is lighter than the rest. The logging lane gate carries 2 locks. One belongs to us. The other belongs to no one. We mounted it beside the gate without a chain as a reminder of the lock Richard cut. Below it, Daniel attached a small wooden sign. It says, "Melting is not the same as disappearing." Richard believed winter would cover the evidence and spring would erase it. But snow can melt without making anyone innocent. And when an HOA charges homeowners for lawful disposal while dumping everything on a neighbor's land, the most dangerous thing in the pile is not always the salt. Sometimes it is the receipt.